G'day everyone. Well, it's going to be an interesting one today. If you're in a housing corp house and you legally occupy that house, that doesn't mean that you can trespass somebody without the owner's permission. Now, the owner of the property needs to give the tenant permission to be able to, if they want to trespass somebody. If you own the house and are actually, the title owner, then you have the right to trespass people. So, if you remember back a couple of years ago, my friend in Waitara, she was having problems with being harassed by the police, and we wrote this little letter to the police. It's seriously 2 pages, and I'll read it out to you. I'll keep her name out of it, but needless to say, this was on the 30th of November 2020, and I sent it to New Zealand Police in Waitara. And it says, "Attention all constables, this shall serve as notice and warning to cease and desist any further unnecessary interactions with and her children, as this is causing to fear for her safety and for the safety of her children, causing alarm and distress. Should New Zealand police officers or constables such as Kirk Sanger, Mark Johnson, Heather Patient or any other New Zealand police employee require to deliver documents using the postal services suggested or hand delivering to her mailbox is sufficient and will not therefore give cause for any direct interaction. Last week, New Zealand Police chose to send 4 employees and 2 vehicles to simply deliver a summons, which is deemed to be a waste of public resources and unnecessary. This interaction caused, shall remain nameless, to again suffer alarm and distress and appeared simply as further harassment. New Zealand Police should be aware, if not, are hereby informed that my friend is clinically diagnosed with a phobia of police, and due to being assaulted and physically injured by police staff on several occasions without reasonable grounds. Should New Zealand Police continue to criminally harass my friend on her or her children, causing further fear for their safety, as prescribed under the Harassment Act 1997, Section 8, legal action against those offenders committing any further harassment will be sought. Under the Trespass Act 1980, now in here I should also have mentioned Section 3 as well, okay, because Section 3 applies because you must be first warned that you're trespassing before you can then be willfully trespassed or be done committing an offence of willful trespass. You're only willfully doing something if you're first told that you shouldn't be there. Alright, so under the Trespass Act 1980, and I'll add in Section 3, Section 4, 1, 2 and subsections 4, any and all New Zealand Police employees are hereby trespassed from my friend's address without exception and including the following employees. Kirk Sanger, now I mentioned their QIDs, the location, cell phone numbers if I have them. I mention these because 1, public information. 2, what I should have done is just identified the individuals, because you can't go after the uniform, you can go only after the person or the man wearing it. Alright, so because the Harassment Act, you can go after the individual, not the office. Alright, so I should have just mentioned Kurt Sanger and the local station that they were from, because you can still serve them at their work address. Okay, so yeah, identifying QIDs and stuff ironically actually puts them in their officer capacity, and I should have kept that out of it, quite frankly, because the individuals can be prosecuted. The police might think they're immune and they can't be prosecuted, but I'd like to point out Wright v Bozale 2016. Nick Wright won $14,000 against Mr. Bozale, who was the police officer that unlawfully arrested him, and he wasn't informed. They breached his liberty, Section 22 of Bora, and many other bits. And I highly suggest to anyone making documents or complaints to put it in a pleading type format, the same as you'd enter a statement of claim or a notice of estoppel or something like that. you need to do it in that sort of format, so that way it's not an abusive process and they can't just ignore it, because it's in the correct format for them to acknowledge it. Alright? Because remember, all of these people you're complaining to, they're all different tribunals. They all have to look at it in the same court type format. Very important that you can go online to the IPCA, you can fill out any complaint, you know, the online boxes that you fill in your details on. It means fuck all, because all that does is you're putting a complaint in the wrong format to them. Okay? They also give the option of sending them a document like a PDF. That is the correct format. You do a court filing type document and put your complaint in, same as you do statement of claim, and that way they're seeing that you're actually entering the complaint correctly, and it's in a format that they have to acknowledge. Alright? It'll make them stand up and take notice, if nothing else. And don't forget to put in your footnotes and the authorities down the bottom, and supply the actual, if you're referencing a case law, get that case law and you attach that to your filings, so they're not off going looking for it, and you're supposed to supply anything that you're referencing to. You know, if that reference is referring to other things, then no, you don't have to do that. But if you're using something as a footnote and including it down the bottom as an authority, which has more power than legislation that you're referring to in the document, then make sure that you supply the actual case law that you're referring to. Anyway, under the Trespass Act, New Zealand police employees are hereby trespassed from my friends without exception. Yeah, so Kurt Sanger, Caleb Turfrey, Nicola Howells, Philippa Joblin, Janine Olsen, Alan Whaley, Raywin Smith, Santina Knowles, perfect little lady she was, Andrew Stilton, Michael Evans, Bryce Allison, Chris Ellenman, Kyle Davey, Rocco Gores, Mark Stevenson and Heather Patient. Okay, so they're just the people that have come round and interacted with her so far. So can't tell me that wasn't more than 2 times in 12 months, because it was certainly more than twice in 12 months has she been alarmed, distressed and harassed. But anyway, so that's what happened with the letter we sent 2 years ago. But I've just been handed what appears to be the police seeking legal advice in regards to this letter that I've just read you. Alright, and this is labelled Response from Legal, and I'll read it out to you. I am a summer clerk working for Lower North and South Legal. This advice regarding my friend's letter has been prepared for you under the supervision of Sarah Mackenzie, my manager. Please forward any questions you have to her, as today is my last day in the office. Please remember that advice from legal is legally privileged and cannot be shared outside the organisation. And of course, they shared this outside the organisation. Real clever. Good on them. Way to go, New Zealand Police Intelligence, showing no such thing exists. You have asked whether you must do anything in regards to a letter which you have received via email from my friend, or whether it can be ignored. So they've asked if they can ignore the letter I've just read you. My friend relies on both the Trespass Act 1980 and the Harassment Act 1997 to assert that any more contact made with her or her children will result in legal action being taken against police for criminal harassment. She endeavours to trespass all police employees from what appears to be her property per Section 4 of the Trespass Act. She refers particularly to a recent event where 4 employees and 2 vehicles were sent to her property to simply deliver a summons, causing her to suffer alarm and distress. She also relies on other instances where she claims to have been assaulted and injured by police. She claims to suffer from a police phobia. I consider it as very unlikely that any member of police is at real risk of prosecution should they interact with my friend. I'm saying my friend instead of her name, so you guys all know. in the future whilst carrying out their normal police functions. However, I do consider it would be appropriate for police to modify in some respects when and how they interact with my friend. A. Do not enter my friend's property in reliance on the implied license to enter and approach the front door. Police can still enter her property if expressly invited to do so, because an invitation rescinds any trespass notice, or in relying on a statutory power of entry, such as when executing a warrant, exercising a warrantless search power. My friend's trespassing of various police officers from her property via her letter does not meet the technical requirements for criminal trespass, like I said, because we haven't put section 3 in, so the warning wasn't given via section 3, so you must first do section 3 before stepping onto section 4 and 5. Moving on. However, she has made it clear to anywhere who is aware of I believe the clerk means to anyone who is aware of her letter, that she withdraws the implied license to enter. Entering my friend's property in reliance on the implied license to enter, knowing she had withdrawn that license, would still mean the relevant officer was unlawfully on her property. Okay? So you can trespass police officers. Or in fact the individuals as well, but all police in general. B. Otherwise continue to interact with my friend where it is necessary to do so for policing purposes, but avoid unnecessary interactions with my friend. If interaction is necessary for policing purposes, and certainly where police are exercising statutory powers and interacting with my friend, I do not consider that a police officer would be at risk of criticism for harassment. However, making unnecessary contact with my friend, general welfare, prevention type contact, might lead to criticism. C. Consider what steps you could take to minimise the impact of police interactions on my friend's mental health in circumstances where you do need to interact with her, seeking advice if that is felt appropriate. My friend has indicated she suffers a phobia of police. It would be appropriate for police to take reasonable steps to try and accommodate that difficulty when interacting with her in future. Criminal harassment. 4. The offence of criminal harassment can only be brought against individuals. If legal action were to be brought under Section 8 of the Harassment Act, there would have to be evidence against the individual New Zealand police employee charged of their actions within the last 12 months, rather than a compilation of many different people's actions. So in other words, the same officer within a 12-month period. They can keep coming round, but even though now they've been trespassed, they know they can't come on the property. The implied license is removed and revoked. They can't do it unless she invites them in, or unless they're exercising a statutory power or warrantless entry and all that sort of jazz. Okay, so, and they know that it's within a 12-month period because they've just stated that sort of thing. And but we'll move on. 5. Harassment occurs when an individual directs a pattern of behaviour requiring any two specific acts over a period of 12 months against a person. Specified acts include, amongst other things, making contact with the person, watching or loitering around their residence, and giving that person offensive material. I don't know about you, but I consider any legal documents offensive material. Surely that's a subjective viewpoint and not an objective viewpoint. 6. For legal action under criminal harassment to be successful in a case such as this, it would have to be proven that an individual police officer knows that or intends that the harassment was likely to cause my friend, given her particular circumstances, to reasonably fear for her own safety or the safety of a person with whom she is in a family relationship. Safety in relation to any person includes that person's mental well-being. Alright? So mental well-being is a category of fear for your safety. You can have a mental fear just as much as a physical fear. In fact, it must surely it must manifest mentally first to start exhibiting physically afterwards. But anyway. 7. It is possible that officers could carry out specific acts in relation to my friend, as the acts cover a broad range of interactions and activities. However, it seems very unlikely that officers who needed to come into contact with my friend while carrying out their normal police duties would ever commit criminal harassment. Oh, really? It seems very unlikely, does it? And that's her viewpoint. Oh my God. Law clerk spent way too long in a room. It is possible that the officer could carry out specific acts in relation to my friend, as the acts cover a broad range of interactions and activities. However, it seems very unlikely that officers who needed to come into contact with my friend while carrying out their normal police duties would ever commit criminal harassment. One or more of the following issues are likely to prevent that. This is how they dance around the head of a pin. Okay? A. They would need to know that their actions are likely to cause her to reasonably fear for her and her family's safety. Unless an officer is personally aware of her alleged phobia, they are unlikely to know this. B. If police are exercising statutory powers such as serving a summons, carrying out an arrest, using force to overcome resistance to an arrest, executing a warrant, preventing a suicide or escape from custody, or acting pursuant to a Search and Surveillance Act power, then provided that they do not exceed their powers, police are expressly protected from criminal and civil liability. See examples of the powers that grant officers immunity from criminal and civil responsibility in the Crimes Act subsections 2, 26, 30, 41, Search and Surveillance Act sections 166 and the Policing Act section 143, unless it can be proven that they acted in bad faith or exceeded their powers. And I think you need to go and read the Law Review 1997, the Bagent case, all about Crown immunity. You guys, police officers, don't have the same immunity as judicial officers or crowned agents and the rest, okay? Again, go read Wright v. Bozale if you don't believe me. Police can be prosecuted and found criminally liable. So, that's what I have to say to this little law clerk so far. But anyway, we'll move on. 8. Where there may be some risk for police is if officers are actively seeking to make contact with my friend to make general inquiries, or in ways that are not necessary police response to a particular policing matter. For example, making contact with her, paying her a visit as part of general prevention, community policing strategy. I emphasise these are simply examples, and I do not know whether these types of interactions have or ever would occur with my friend. To minimise these risks, I recommend that you look to limit interactions with my friend. Therefore, I would recommend that police avoid making contact with my friend for the kind of general prevention community policing reasons referred to above, or referenced above. 9. It is most difficult to resolve the question of how to manage the need to make general inquiries of my friend in respect of particular policing matters. If we assume my friend's alleged clinical diagnosis of a phobia of police is true, and I'm not aware of any information that specifically calls that assertion into question, then she might reasonably fear for her mental well-being when faced with police officers, even where they are conducting themselves with their usual professionalism. There is no explicit general power to carry out general inquiries. There are some specific powers, such as in the Search and Surveillance Act and the Land Transport Act. Police simply approach individuals to make inquiries and rely on them obliging police, although there is sometimes only a very, very snippet of any obligation to do what they're asking. Generally, do not answer questions unless you are legally obliged to do so. Section 113, 114 of the Land Transport Act, where they have the power to request your identity, name, date of birth, address, phone number. But 114 subsection 5 is also quite interesting, because it states they can only detain you for 15 minutes for the purposes of identification. So Always time your interactions. Just another little bit there. Trying to help there, New Zealand Police. Of course. Police simply approach individuals to make inquiries and rely on them obliging police. So the explicit statutory protections from criminal and civil liability don't apply. Good to know. 10. I suggest that the best way to manage the risk that making general inquiries might cause my friend to fear for her mental health is to take steps to minimise that distress. In order for the offence of criminal harassment to be made out, her fear needs to be reasonable. If police have taken steps to manage her alleged phobia when approaching her, then her fear may not be reasonable. And this is how they're basically explaining how to get around the reasonability. Alright? Isn't this lovely? Where are we? If police have taken steps to manage her alleged phobia when approaching her, then her fear may not be reasonable. If it's not reasonable, then criminal harassment would not be made out. Well, why don't you just give them the tips on how to make things, still legally work? This is disgusting. 11. So I recommend that you consider what strategies might be employed when dealing with my friend in future to minimise any distress she may feel when confronted by police. This is not an area where I have any expertise, but a police psychologist may be able to offer some suggestions, and I noted my friend has herself suggested that avoiding unnecessary interactions with her by leaving paperwork in her letterbox would assist. I make some further comments on this below, but where this can be done without breaching any legal obligations or compromising maintenance of the law concerns, it seems a reasonable step to take. Yeah, it's called using a letterbox. 12. Of course, in practice, it seems very unlikely that a prosecution for criminal harassment would ever be entertained against a police officer carrying out their police duties. Oh, God forbid. These suggestions may seem excessive, particularly if you have doubts about the validity of an alleged phobia. However, taking these steps would not only reduce the theoretical possibility of such charges, but also ensure police avoid causing my friend undue distress. Well, isn't that the main point? I mean, surely you shouldn't be worried about prosecution if you're doing things correctly, eh? They would also avoid any potential criticism from the IPCA, for example, that police have failed to take into account a mental health matter of which they have been notified when dealing with my friend. Trespass. 13. Section 4 of the Trespass Act allows any person to be warned to stay off a place by the occupier of that place, where the person is trespassing, has trespassed, or is likely to trespass on that place. It is an offence under that section to willfully trespass on that place within 2 years of the warning being given. It is assumed that my friend is the occupier of that address, the property which she endeavours to trespass all police employees from. 14. The delivery of the warning must comply with Section 5 of the Trespass Act. This states, a warning under Section 3 or Section 4 shall be given to the individual person concerned either orally or by notice in writing delivered to him or sent to him by post in a registered letter at his usual place of abode in New Zealand. Yep, and your work address is considered a perfectly legal place to do service. I would like to say that to counteract that little point, my friend simply just needs to say to anyone officer that decides to show up, "You're trespassed, please leave." It's really that simple. I mean, if they are exercising their proper police powers and doing whatever it is they're doing, then they have that legal loophole to still trespass because they're doing their duties. But if it's just to go around to make inquiries or safety check or anything like that, anything where she hasn't expressly called them and invited them there for service, they're trespassing. So, and it is assumed, well, they can easily look up in the land registry that address and find out that she is the title holder and the legal occupier. So fuck them to that sort of response. 15. It is enough to satisfy a trespass if a group is at a place and it is made clear to the whole group that they must leave, as found in Scold v Police. Scold v Police refers to a law review, the New Zealand Law Review 197, which was back in 1982, where it was basically found that if you've informed an entire group, then that's sufficient. So yeah, I'll reread that for you. It is enough to satisfy a trespass if a group is at a place and it is made clear to the whole group that they must leave, as found in Scold v Police. So she doesn't need to identify each individual officer and tell them they're trespassed. If they're all standing there in a group, she just needs to say it to the group: you're all trespassed, leave. Of course, after getting their full QID numbers, because you always want to make sure you have their identity. These days they have to have a photo ID with their full fucking name and their full QID number. So, you know, the old epaulette turn isn't sufficient. Not according to the Policing Regulations 2008 Section 4 anyway. Right, moving on. 16. The warning given by my friend to stay off the property has not been sent to the usual place of abode of the individual person, but rather it has been delivered to a police email naming many employees and endeavouring to also trespass others who are not named. Well, quite frankly, my friend, I'm sure if she didn't just email this to them, it's really easy just to put it in a post, send it by registered post, done. Okay, it's that simple. You can send it to their work address on a registered post. They have to sign for it. Alright. The delivery of the trespass notice does not comply with the requirements of service, and so it would not amount to a criminal trespass for the named police to go on to my friend's property. Okay, so they're saying because it was only emailed, it's not considered full delivery, so you must do it via the post to their normal work address, or serve it in person like I did with the police officers in Manukau. Just walk in and hand it to them, they've been served. Yeah. However, while technically not valid for the purposes of criminal trespass, my friend is clearly intending to revoke the implied licence for police officers to enter onto her property, which she is entitled to do. Love that, don't you? 18. I recommend that district staff should proceed on this basis, that they no longer have an implied licence to enter my friend's property. They should only enter her property where they do so in reliance on a statutory power of entry, such as when executing a warrant, exercising a relevant warrantless search power, etc. I recommend you place an alert on NIA. Advise district staff of her wish that police not enter her property. While it's not strictly necessary, this would avoid any criticism that police were intentionally ignoring her wishes. Ensure there is no question of police being unlawfully on her property, and would also assist in ensuring that police didn't unnecessarily aggravate her alleged phobia. Document delivery. 19. My friend says in her letterbox that should any police employee need to deliver documents, postal service or hand deliver to her mailbox is sufficient and will not give cause for any direct interaction. 20. Documents filed in the High Court which must be served on a party can be sent to the postal address of a party. If police need to serve any such documents, they should be posted to Mrs. address. Wow, you're actually telling police to use the postal service. It's gotten that bad. A summons must be personally served by leaving the document with the person, or if they do not accept it, by putting it down and bringing their notice to it. For all Category 2, 3 and 4 offences, that's criminal offences, personal service with the person or at the place of residence with an over 18-year-old member of the family who lives there must be actioned. postal service can only be used if it is a Category 1 offence, like a speeding ticket or a parking ticket. 22. My friend's statement that all documents must be sent through the post or hand-delivered to the mailbox can be honoured by police to avoid confrontation as long as they are not summons for Category 2, 3 or 4 offences, or any other documents which require personal service. If they are summons for Category 2, 3 or 4 offence, a police employee or document server could be used to serve documents upon her. So a police employee, not particularly an officer, so just an office clerk or a process server could serve her the documents and still be valid. Simple really, isn't it? Conclusion. The risk of successful action against police if police ignore my friend's requests is, in my view, low. Brackets, although not zero. And especially if she's got some friendly help. It won't be a problem at all to file papers. I mean, I'm successfully getting papers into the Court of Appeal now, first pop, so I'm more than happy to help her with any documentation she needs help with. However, I consider it would be unreasonable and imprudent not to take some steps to modify police's interactions with my friend in light of her correspondence. It's clear that my friend finds interacting with police distressing and wants to minimise her interactions with officers. 24. Police does not need to avoid any interactions with my friend. Police officers can still exercise all their statutory policing powers as required and serve documents on my friend when necessary. However, police should not initiate unnecessary interactions with my friend, the sort of interactions that can be beneficial to maintaining connections with the community but are not strictly necessary of support or supported by specific policing powers. Police should not enter her property unless they are relying on a statutory power to do so. So, ta-ta your implied right of access. Are you listening, gentlemen and gentle ladies? Are you? Are the individuals that work for the New Zealand Police listening? 25. Where there is good reason to make contact with my friend, particularly if police do not have an explicit statutory power that empowers police to initiate that interaction, such as where a matter has arisen and police want to make general inquiries of my friend, police should take steps to minimise the potential distress that interaction may cause. You may wish to identify some potential strategies in advance and to seek some guidance from a police psychologist on what may be effective. Ngā mihi mea ora, Savannah Hiha, Summer Clerk, Legal Lower, North and South, Legal Services Group. So guys, there you go, you have it. From the police's own legal advice people, the response that they didn't want to make out of their organisation, but gave it to anyway, in response to my friend's letter notifying them of criminal harassment and trespassing. So yes, you can trespass police. It really does limit them, and it doesn't have to be a police phobia. It can be anything. It can be something like IED, intermittent explosive disorder, or lots of disorders that cause, dysregulation of your emotion. So, I mean, there's lots and lots. So, I'll leave you all to it. I'll let you all absorb that, and I'm going to rewrite one because the trespass is almost up. It's almost been 2 years, so I'm going to rewrite it slightly differently this time round, and make sure Paula sends it or hand delivers it via post, because as they've said themselves, so long as you show up and just bring their attention to it, you can then walk away. It's been served, according to their own legal advisors. Anyway, so you can walk into any police station and serve it at them, and it's for all police employees. See you guys, and do enjoy the rest of your day. Bye now.